Hello, that's Tillman.
Tillman.
Hi, Lionel. Can you hear me?
Yes, I can hear you fine.
Very good. I think I need to switch my camera on. Here we go.
Hi.
Hi, Ian.
So I only have a jacket on because you guys told me, so I'm going to take my jacket off.
You may.
You should never listen to the Europeans when it comes to how to dress. You guys have it right.
Let's try this out. No. You don't want to see my belly.
People might pay for that, but not me.
So we have 100 participants, roughly. That's pretty good.
That is good. I think I'm going to get a drink. I'll be back.
Do that. I'll do the same. Ian, you okay alone?
I'll just chat to myself.
Yeah, very good as always.
Hi, Mattia.
Hi, Ian. Nice to see you.
And to you.
Thank you. I'm moving to check whether the camera is. We are the only two entering the room.
Tillman and Lionel have gone to get a drink.
Okay.
Here I am. Hi, Mattia.
Hello.
Oh, the Italian. Very good.
As you know, I'm usually sleeping also with my tie.
I got a partner like that too. Ian knows him quite well.
So have you, are you all back at work in real Europe, as you put it the other day?
Yeah.
And is everybody still wearing suits and ties then?
Not so much.
Depending if I'm meeting client or not. Sorry.
I'm glad to hear you're all back at work because our offices, you can go in if you want, but you have to wear a mask if you're outside of your office. The restroom can only be attended by one person at a time. The cafeteria is locked with a padlock, so you cannot access anything in the cafeteria. No coffee, no water, no refrigerator. The restrictions are tremendous.
So that sounds like it has removed all of the fun that existed in an office.
It makes it absolutely useless to want to go to work, right?
Yeah, we're thinking of the same thing, how to get people back, and we're thinking of those people who perhaps live on their own and need a bit of a change, but coming into an office and not being able to do very much there's marginal benefits there, especially when you have to commute in.
Yeah, as I have a very tough commute, which means 10 minutes by bicycle, I'm okay with it.
I think I'll need to get a background like yours, Tillman. Cartmels and
actually-
Ransford.
This is really my office wall, and I just took a picture and used it as a background.
Yeah, clever.
I'm very loyal to my firm. Hi, Anne-Charlotte. Bonjour.
Morning, everyone.
Oh, morning,
Good
Dana.
afternoon.
How are you? Sorry for, I was actually on the wrong link for about 5 minutes.
That's okay. Just put the audience on that one.
Exactly.
That would be good.
We'll put them in the waiting room. Morning, Isha.
Morning. Sorry, just in the background.
Can you hear me now?
Yes, very good.
Everyone
Oh, great.
today.
Wonderful.
So, Anne-Charlotte,
How's everyone doing?
We're good.
Hi.
Oh, my speakers are not working. Oh, there we go. Okay.
I'm going.
Anne-Charlotte, just so you know, I'm a big fan of Ladies First, as you know.
All right.
So my first question will go to you, and it will
Oh,
be about Corona and court hearings.
that will do. Thank you.
Mattia, go get a drink, Mattia.
Exactly. I'm going to take something to drink.
All right.
Mattia is wearing the tie. Is he the only one?
Yes.
All right, Mattia, you had
Gets
to
the
follow the
award.
rules.
Well, Mattia's a very good-looking man. I mean, I can't compete. So, you know, I've got a jacket. That's about as far as I went today. All right. So,
We have more than 30 Celsius today in Munich, I believe. So
Wow.
climate change, you could also call it global warming, but that's not a term used in the US so much, I understand, might really take place.
I think it's used by some. Not all, but it's used by some, certainly. I use it.
And the
No need to
second
comment,
point-
Lionel. That's fine.
I'm sorry, Tillman. The second point that you want to raise after COVID,
Just current trends. What's going on in the courts? What are
Oh.
trends that we can see in patent litigation?
okay, thank you.
I just had a hearing yesterday in court, so
Hey,
A
breaking
real
news.
one or a video conference?
it was in person.
All right.
Yeah.
With a mask or without?
So the written instructions said that we had to wear a mask, but once we arrived in court, we were given the option. And once I said I didn't want a mask, then the judge gladly agreed and took his mask off.
It's very frustrating to plead a case and to not to see the judge's face. Like, oh, are you, how bored are you?
Exactly.
Lionel, pronounce your last name for me.
L'avenue, just think avenue and throw an L in front.
Perfect.
That's very French.
L'Avenue.
How doing, Anne Charlotte? Are you at home or in the office?
No, I'm in the office.
Very good.
And Charlotte, you're Le Bihan?
That's horrible in English, but it's
Thank
Le
you.
Bihan in French, but
Le
Le
Bihan.
Bihan in English. There's no other way to pronounce it. It's a terrible name in other languages.
Was it yours by birth or by marriage?
No, by marriage. My birth name was even worse. So before I knew what it meant, because it does have a meaning, which I won't share with you before the webinar.
Keep
You're from
that for next
Bretagne.
time we
Your
meet
wife
in
is from
person.
Bretagne, Tillman, so she must know.
Yes, I'll ask her.
So Tillman, I did do a single slide if we wanted to show it, just in the background.
Sure.
And what I might do is what I've learned is having it up actually as people enter the room is both helpful for me afterwards because I can cut to it, but it also makes sure that people know they're in the right room, right place. So
Sure, that's fine. However, when we start the real stuff, you might want to get rid of it.
that's right. So what we'll do is in a second here, in 2 minutes here, we'll put it up. Isha will let everyone in the room. I'll be quiet for a minute as people are coming in, and then we'll wait for a mass, and then I'll take it down. I'm gonna get some water as well.
That's not better, is it? Those video conferences are terrible because you see yourself speaking. It's just
I hate
awful.
it. It's horrible. This is actually your office, or that's a background. It's a fake background that you put, right?
It is a photo of the wall behind my desk, so it is really my office. I'm in charge of marketing.
You have the sign in your desk?
I have it.
I can't believe you.
Hang on. Here you go. Now watch this.
Well, you
I'm
see,
the
that's the
marketing
difference between you
partner.
and me.
I
You're
need to have
corporate.
it.
You have your logo, and I have the stones behind me. That's the very big difference between you and me.
It is a big difference. I have the stones in my heart, if that helps.
Somewhat.
All right.
As long as it's not the stones in your kidney.
No truer words.
What was the concept where you have a picture on your
Oh, in
wall?
my office. Yeah, that was just before I went on sabbatical. The last time they toured London, and I was very close to the stage, so took an image on my iPhone, which I show off to people when they visit. Of,
And that
Mick.
was Mick Jagger, right?
It was Mick Jagger, yeah.
Yeah.
Not bad.
All right. So we
Ian
are.
sort of knows Mick Jagger.
Yes. I've been close to him.
Okay. So we are right at, well, 9:01. We've got about 24 people in the waiting room. So I'm going to share the screen here, put this guy up. Everyone ready?
Sure.
Yep.
Okay. Isha, go for it. Good morning and welcome, everyone. We'll get started here in a second.
That's nice.
As folks are coming into the room, we ask you to put yourself on mute, and we'll get started here in just a second. All right. Well, it looks like we've got a good group so far. Other folks will join as we get started. Good morning. I'm Dana Calavrulli. I'm the Executive Director of LESI. Happy to have you all with us this morning for our webinar from the LESI Dispute Resolution Committee. An update on update on global patent enforcement for licensing professionals. And we've got a great crowd today, led by Tillman Mueller. You know, I did the pronunciations before, and I'm now going to play with them. But I want to just give a quick introduction just of Tillman. Tillman's a partner, one of Germany's leading patent litigators. He has extensive experience not only in defending against, but also creating, evaluating, and enforcing extensive licensing programs, particularly in the area of SEPs. He will talk more about what he does throughout the program. Second, we have Anne-Charlotte Le Bihan from Bird & Bird. Anne-Charlotte is an IP partner based in Paris, also with significant experience, but both in contentious and non-contentious IP matters. Again, she will talk a little bit more about her background, I hope, throughout the program. Our third, Ian Kirby from LES Britain and Ireland. Ian is a partner in the dispute resolution team at Carpels and Ransford. He focuses on multi-jurisdictional patent litigation and IP disputes, has over 25 years of experience doing so. Fourth, we have Mattia Dalla Costa. Mattia is from our LES Society in Italy, LES Italy. He's also the president of that society. Mattia is an Italian attorney specializing in IP, focus on patent infringements in several jurisdictions. He speaks 5 languages. I've seen him very ably present both in English and Italian. I'm working on my Italian as well, so I can attend those sessions. So thank you, Mattia, for joining us today. And last but not least, Lionel Lavenue from Finnegan Henderson, law firm here in America. Lionel was just recently in court yesterday. Maybe he'll tell us a story about his experience being in court during COVID. His practice focuses on patent trial litigation, including nearly 200 patent cases, more than 200 depositions, as well as managing large patent portfolios. So thank you all for coming and speaking today. Thank you to the crowd for listening. Tillman, I'm going to turn it over to you and have a great program.
Yeah, thank you very much, Dana. Good morning, good afternoon, good evening, wherever you are. It's a pleasure to have so many people with us. We're going to focus on various aspects of, say, global patent litigation. We want to do this in a way that allows for discussion. So you won't see any slides. You will not see any frontal speeches or something like that. We're going to do questions, answers for.
I think we may have lost Tillman here just for a second. Can everyone hear me?
Yes.
Great. We'll give Tillman a second here to come back. If not, we can just move right on to the first speaker. Yep, it looks like Tillman, it looks like we may have lost Tillman here for a second. And Charlotte, you were first up on the agenda after Tillman. Do you want to start us off, or should we wait for a second for Tillman to return?
I can do either way because I knew the question that Tillman was about to ask, but it's kind of unfair for him not to ask the question.
Well, you have the choice. You can change the question now. You know, you have that option. So why don't you kick us off, if you would?
Right, anyhow, well, hello everybody. I'm very glad to be part of that beautiful panel and missing Tillman. But the first question that Tillman was about to ask was a very, let's say, momentum question. It's related to how French courts have dealt or are dealing with the COVID situation. In France, some of you might know that we've been on total lockdown since March 17, as far as I remember, and we've had crazy times until early June. So our courts have been shut down, and we've had, let's say, 2 months with no hearing and basically only exchanging briefs. But the brief exchange written part has taken place quite smoothly. Everybody's played the game mostly, and courts are coming back to normal. And when it comes to patent litigation, there was an option for having trials without a hearing, but everybody has come to a consensus that this was not an option, and hearings have started again. We just had a hearing, PI hearing in a patent case 2 weeks ago. We're expecting the decision by the end of the week. So things are coming back to normal. And if I may have a positive thought about this, it may be a new era that's coming in, because our courts are taking this into consideration. They've explored, experimented one video conference hearing, as far as I understand, and it may be that this would be a possible option in the years to come. I'm not saying that this will be the rule, but this could possibly make it possible. So I think that, like in many other areas, people are trying to get the positive side of things, and possibly have a system that would be even more efficient in the months and years to come. So Tillman, I did answer your question that you didn't get the chance to ask me, but now I'll give you the floor as a moderator again.
Thanks, Anne-Charlotte. That's much appreciated. I mean, as a German, you're used to getting kicked out right away these days with Berlin Airport and Diesel and you name them. Anyway, I hope I'll be back for a bit longer now. Thanks for explaining the situation in France. Maybe Ian, how is it in the UK when it comes to video hearings?
Yeah, there's a lot of similarities to the position in France. I have to say that when we went into lockdown, one of the things that I was thinking about, because some of my partners were just finishing a major trial, which, as people may know, in the UK, there's a lot of oral advocacy, there's a lot of cross-examination, and in this case, there was a mountain of documents, and I did wonder how the courts would cope. And the way that they've coped has been surprisingly efficiently. I say surprisingly because just before lockdown, it seemed that the ability for someone to sneeze in court and for everything to come to a halt was very real. And then as soon as we locked down, everybody moved to doing things by video conference and Zoom quickly and efficiently. It has led to a different way to prepare. So multiple screens have been purchased by anybody who's doing the advocacy. We are moving pretty much seamlessly to electronic bundles of papers, which many of the old timers like me have been resisting, but when you're forced to use them, you actually find many advantages about using them. So it's all good. I looked at the number of patent cases that we had in 2019, which was 55 for the year in the UK, and this year we've had about 25 start already. So I don't see a significant change as a result of COVID or the lockdown. There is a little bit of a downturn in relation to soft IP, so the copyright and trademark cases, but the major litigation for the pharma and tech companies, which is what amounts to most of our work in the UK, that looks rather constant.
Thank you very much for these insights, Ian. Mattia, how is it in Italy, which is a country which has been particularly hit hard by COVID-19? Any video hearings?
Yes, indeed. I mean, as you probably all of you know, there was a quite hard lockdown starting from March 2020. And I have to say that I was quite surprised how the judges could react on that and improve their IT capability. I mean, all civil proceeding not involving family law were postponed to a date after May 11th. And then from May 11th, the legislature decided that each court could decide individually how to apply the necessary measure in order to prevent the spreading of COVID. And mainly the court use three different approaches, jointly or severally, depending on the case. The first one was carrying out the civil hearings that do not require the presence of the person physically, to have an exchange and electronic filing of short written notes to the court without appearing in the hearing, and then the judge collect the notes of both parties and decide how to proceed further on. Second option was just a postponement of many hearings not considered really necessary, especially in case other than preliminary interim measure. And the third one was in fact the carrying out of civil hearings by Microsoft Teams. So the judges are using this platform, Microsoft Teams, and hearings are done on a regular basis with this platform. So I think a good reaction coming from the judges.
Thank you very much. Lionel, how about the US?
So in the US, it's very much like what Mattia said in Italy, where the judges and the courts are able to decide on their own. We have, of course, the federal systems and the state systems, and between those, there's differences. But even among the federal systems, each federal district court judge has his or her own ability to make a decision to have an in-person hearing or to have a video conference hearing. Judge Gilstrap in the Eastern District of Texas is still conducting Markman hearings and has begun to have trials. So, and those are in person. The interesting thing that you face when you have these in-person hearings is if the client is from the US and they're not perhaps from New York or New Jersey where there are restrictions, then they can attend the hearing. But if they're from outside the US, then international travel is very difficult. There's 14-day quarantine requirements, not only to come into the US perhaps, but also to go back to their home country. So most people don't want to travel, right? So if there's even an in-person hearing, the clients are not able to attend if they're from outside the US, which is unusual. I just had a hearing yesterday in Washington, DC, and there it was even unusual once again, where the chief judge of the court had decided that the entire court would be closed until September. However, the judge that I appeared before did not agree with the chief judge. So the judge secured a hearing room off-site, and we went to an off-site hearing room and conducted our argument at another location, which was not the courthouse, because our judge wanted to have an in-person hearing. And I'm sure you want to know about masks. I wanted to know the same thing. We were given written instructions that we had to wear masks, of course, as we were walking through the facility, but also during the argument, which I thought would be rather unusual to have a mask as I'm making the argument. Also, I was worried that I wouldn't be able to see the judge's face if I was doing well or not. And when we appeared before the judge, he gave us the option moving our masks argument, and we of course agreed. So during the actual argument, we did remove our masks, but of course, once the argument was over and we left, we put our masks back on.
Thanks, Lionel. That's very interesting. Maybe just a few words about Germany. I mean, we had basically 0 hearings in, say, March and towards late April. But as of late April, beginning of May, hearings started again, as always, so to say. So the courts are back on track when it comes to infringement and validity. In particular, the Federal Court of Justice, where I had the pleasure to be in the last couple of weeks 3 times, is conducting a hybrid approach, which is interesting. They allow counsel, pleading counsel, to be in person in the courthouse, but they allow additional counsel plus the client to participate by video conference. And they're also using Microsoft Teams. Such hybrid approach works well, and the clients were happy with it so far, which is something which I could imagine might take place more often in the future, especially if you want to avoid international travel related costs, so to say, stuff like that. Now, what we've also seen is, in particular at the Munich Patent Infringement Court, is full-fledged video hearings. So only the judges were in the courtroom, pleading counsel was in their offices, and the hearing was conducted by video conference. That's something which is done, but which is not frequently done. Reason being, in my view, that it is very difficult to see precisely the reactions of the judges to your arguments. And it also limits you as pleading counsel in your abilities for oral argument, including gestures and so forth. So I'm not a big fan of it, especially in patent litigation, where you might want to go to the bench, discuss a specific piece of paper drawing, maybe eye to eye with the judges, but it is possible. Under German law, nobody can be forced to do video hearings, but you could do it if both parties, so to say, agree. What does no longer work is defendant's delay game, asking for postponements of hearings because of corona concerns. The hearings take place, and then it's just a matter of how many people are allowed to attend in person. If the client cannot attend in person but wants to attend in person, doesn't matter for the courts. It is not necessary in their view. You can argue about practical things, of course, but the hearing will be conducted. Maybe, if you agree, leaving that very trendy topic and go to some other trends which we might have seen in our various jurisdictions. Ian, you already mentioned a few numbers in terms of UK patent litigation. That seems to be business as usual, which is great to hear. I mean, we've heard of several Supreme Court decisions coming out, being about to come out. What's the news from the UK, so to say?
Well, so I took a look at the patent court list in preparation for today, and what I saw was what I have been seeing for the last few years. So I don't see a big change in what is the majority of the work for the English courts, which is life sciences cases and tech cases, and then a sprinkling of engineering and other kinds of cases. So no big change there. We haven't seen the beginnings of the disputes in relation to automotive that I think you'll probably talk about in relation to Germany. It's understandable that Germany's leading with that. And with AI, which is much talked about, I haven't seen a lot of evidence of that either. I perhaps wonder that people are still trying to figure out everything to do with AI and where the rights are and how to protect them, and we're a little while away from people suing on them. I suppose a significant thing in the UK has been the introduction of the doctrine of equivalence, which is something that we did not have until recently, and many of us thought we would not have it. But in 2017, there was a bit of litigation involving activists, and that did go to the Supreme Court, and that did lead to the introduction of that concept in English law. Many thought that the Supreme Court, who were populated mainly by non-patent lawyers, the judges, many thought that decision was wrong or shouldn't have taken the steps it had, and were fearful of how that might be, how that might impact patent litigation in the future. What we've seen since then is from 2017 to 2020, an increase in the number of cases where doctrine of equivalence is included in how the case is argued and pleaded. And the current level of that is about 35% of cases include that kind of claim. but a very much smaller number include that kind of claim in the reasoned decision, meaning that although these arguments are advanced, in a much smaller proportion of cases are they actually relevant to the final decision. Another thing that was alien to us was the idea of file prosecution being relevant to the decisions on infringement, the prosecution history, something which is of course common in the States and more common in other countries other than the UK. That is also now, it's also possible to argue infringement by reference to the prosecution history, but again, it's very rare. And I could only find one case where it was argued successfully, and I say that with caution as well, successfully being that it contributed to the court's reasoning as to why there was infringement, but it wasn't determinative. So that's probably the biggest change that we've had to cope with. It does mean that we have to think about things afresh in every case now, and the idea of perhaps running some sort of equivalence argument, which we haven't been used to, is one that we're all spending lots of time on.
Thank you, Ian. If you allow me a consecutive question, maybe it's too early to answer that, but let me throw it out there nevertheless. Now that you're also looking into doctrine of equivalence, that means approaching continental Europe, not really Brexiting it on that in that regard. Practically speaking, do you think that the overall scope of protection of patent claims assertable in the UK has broadened? So do we have now something in addition to literal infringement, or is it more that something is cut off from the literal scope and now called equivalent scope?
I think we're definitely moving closer to how you would view things in Germany, for example. I think the significance of the decision, whether you like it or not, is that it's there. It's not going to change unless there was another Supreme Court decision which overruled it. And it's definitely true that from the stats that I've given, that is being argued increasingly frequently, and it's being done because there is the intention of those who are arguing it to find ways to broaden out the scope, definitely.
Mm-hmm. Interesting. Anne-Charlotte, how relevant is the doctrine of equivalence in French patent litigation?
Well, it's been relevant it was relevant even before I started litigating. So that's why, unfortunately, that's starting to be a while ago. So we've lived with the doctrine of equivalence for quite some time, and French courts are quite well, let's say, educated in implementing a doctrine of equivalence. So this is something that we're totally used to. Nothing brand new, and happy to see that for once we're starting to get closer to the UK when we run an infringement analysis and see the same risk as over the English Channel.
Thank you.
So yeah,
I mean,
this is different.
Looking at it from the German perspective, I mean, we had ups and downs when it comes to the doctrine of equivalence. Maybe some 10 years ago, doctrine of equivalence was dead. I mean, it existed in the law, but you never had cases of equivalent infringement. Then the case law loosened, so to say, over time, and we're now back in a period where more and more cases are also decided because of equivalent patent infringement. Still, and that sounds very similar to the UK, it's only a fraction of the cases. It's by no means high numbers, so to say, which means from a strategic perspective, it's not an argument you can really count on. It's maybe an auxiliary argument or an additional arrow you might want to shoot, but again, nothing you can kind of count on. Mattia, how's that in Italy?
Unmute. Maybe it's interesting to know the number of patent cases we had in 2019. Based on the information I get from that IP, which is really not complete because they do not count for the time being also the patent case in courts in the south of Italy, like Bari, Napoli, and so on. But taking into consideration the court cases in the north of Italy, we had in 2019, 542 cases. And it's interesting to know that 40% of these 542 cases were interim measure. Were procedure on the merit, and 60% are interim measures, so injunction, seizure, description, and so on. And the distribution, the geographical distribution among the different courts, say a percentage of approximately 37% in Milano, 22% in Venice, and 10% in Torino, and 8% in Roma. And coming back to the doctrine of equivalence, I have to say that what I have seen in the last year is definitely an increasing of claiming the doctrine of equivalence and the contributor infringement as additional arguments in order to claim an infringement. So the plaintiff usually also try to give some grounds in order to justify, if it's the case, also an infringement under the doctrine of equivalence. In generally, with regard of the industry, I have to say that Italy, the scenario of Italy is quite traditional. So a lot of patent infringements related to engineering, life science, pharma, less on other topics like IoT and so on. But what is interesting is the increasing of cases related to infringement of apps application. And this is particularly the case in the court of Milano. We had also a very interesting decision coming from Milano a couple of months ago, where there was a case related between an Italian company and Facebook. And Facebook has been condemned for parasitic appropriation and violation of copyright and unfair competition, because it was considered that Facebook had access, because it was, maybe very briefly to explain, was a geolocation app allowing using the link of Facebook to let understand your friend or your contacts in which restaurant, in which places you were, and the value you gave to the restaurant and the places. And this application necessarily had to use the data coming from Facebook. And the court of Milano decided that despite of the fact that there was not an access to the source code of the app of the Italian company, nevertheless for Facebook was possible to understand the operation of the program and the way in which the application communicated with the application programming interface of Facebook. And so the court decided finally that not only the reproduction itself of the app, but also the adaptation and transformation or other modification of the app should be authorized by the author, which was not the case here, and so Facebook was condemned. So more and more, maybe because of the many Italian startups doing with app, this is a new court cases coming on. Thank you.
Thank you very much, Mattia. I found it very interesting that you emphasized that the amount of PI, or say interim proceedings in Italy, is even higher than proceedings on the merits. That's a topic we're going to cover later in a bit more detail, but that's certainly going to be an important point. Lionel, looking maybe at the US, what's the latest there? I'm hearing we have now several courts in Texas who might be speedy. I'm interested in the technologies that are at issue, and I'm interested in whether or not there's a decline in case numbers. What about NPE litigation? What about competitor litigation? And what's the killing rate at the PTAB these days?
Okay, that's a long list. I'll cover all of those.
And I asked you to put short answers to that long list.
Yes, so to answer those, the most interesting thing I think that we've all seen is everyone expected the number of cases to go down because of COVID. And that did not happen. We are flat in the number of filings over the last 3 years. So the only thing that we can figure out is that all of these NPEs who had nothing to do because they were sitting at home for COVID decided to write complaints and file new patent cases. And that's why there's not been a decrease. There's been a consistent number of filings. The interesting thing about the NPEs is of all of the new cases filed in the US, 85% have been NPEs. So 15% competitor cases, 85% NPEs. As far as the technology areas, high tech is of course the #1 area. That's where the NPEs are focusing. The 3 companies that have seen the most lawsuits filed in the US in order are #1, Samsung, #2, Huawei, #3, ZTE, #4, Apple, and #5, Microsoft. So NPEs, their primary target has been perhaps what they believe are easy pickings for Huawei and ZTE because they're both Chinese companies and they're in the news a lot. And so they believe that they are a target-rich environment. And then, of course, once you get beyond those 2 targets, for what many NPEs believe are easy targets, then, of course, you have the 3 high techs, right? Samsung, Microsoft, and Apple. And that's who the NPEs are going after. As far as the courts, there's been a dramatic shift in the lawsuits and where the lawsuits have been filed. As anyone knows who follows US patent litigation, the Eastern District of Texas has traditionally been the #1 location to file patent infringement lawsuits, and it no longer is #1. It's not even #2, it's not even #3. And all of that has resulted from the fact that the Federal Circuit has clarified that in order to sue in a particular court, then the defendant has to have some business there, a place of business, some business in that jurisdiction. And so that's made it very difficult for the Eastern District of Texas to maintain its hold. There is an exception, is if you're a foreign entity, then that rule does not apply. So if you're a foreign entity, then you can still sue in the Eastern District of Texas. But like you said, Tillman, there's been a tremendous change in Texas. And the change is instead of the Eastern District of Texas, now all the lawsuits are in the Western District of Texas. And that is because we have a brand new judge in the Western District of Texas. His name is Judge Albright. And he has actually gone out and advertised that his court is willing, ready, able, and happy to accept new patent cases. And so his court, located in Waco, Texas, has seen a 700% increase in new patent filings over the last 2 years, which is a tremendous amount. And like you said, the reason that he was advertising that he was a good location for court for cases is the speed. He was telling plaintiffs that he would be speedy, and he was also telling defendants that he would be speedy as well. He has special procedures for patent cases that make it very effective. However, he's still not number one. He's number three. The Western District of Texas, is number two. The number one place in the U.S. right now to file is Delaware, and that I think will continue to be the situation because the Delaware judges, that they all are able to carry probably more together as a group of judges than Judge Albright is by himself, even though he's certainly willing to take on a lot of cases. So I think I've covered all of your questions. The killing rate in the IPRs. So if you are sued in district court for patent infringement in the U.S., many of you know that you can go to the patent office, to the PTAB, the Patent Trials and Appeal Board, and ask the judges there to invalidate a patent through an IPR procedure. And there has been, of course, a steep incline of cases, of IPR cases that are filed. And however, even though there's been a steep incline in the number of cases that are filed, there's been a decrease in the success rate. So when IPRs initially came out, the success rate was in the 90%, and then it's gone down to the 80, 70, 60, and now it's in the 50%, Tillman. So now the success rate of killing a patent in the patent office is down into the 50s. And
does it include maintenance in part?
Does it include what?
Maintenance in part, so partial invalidation?
That does include partial, but the thing is that in the IPRs, it's usually either a yes or no. It's not a partial. So it does include the partial. It's just that's a very unusual situation to get a partial. Usually the judges find all or nothing. But you are right that the partial determination, and what Tillman's referring to is let's say you have 20 claims and you challenge all 20 claims. Will all 20 claims be knocked out, or will all 20 claims survive, or will 18 claims be knocked out and 2 claims survive? And that is something that is changing. You're right, Tillman, that originally it was all or nothing, and now it's more of a split decision. But the reason for that is that the Federal Circuit said that that you could no longer, if you're a petitioner and you're challenging an IPR and you ask for all the claims to be considered, the judges at the patent office were originally picking the claims that they would determine. Now, if you challenge the claims, they have to consider all the claims, which, like you said, will result in a split decision, perhaps.
Yeah, thank you. That's very interesting, and that seems to be a very relevant change over time now, since the AIA PTAB proceeding started. Anne-Charlotte, France, maybe the latest on case numbers to the extent you know, of course, and what's the trend there in terms of technologies? I mean, the evergreens are pharmaceuticals, high tech is relevant. Are there other areas which are relevant in the French courts these days?
In terms of numbers, unfortunately, it's very difficult because they're back in the days when Darts IP had good figures. We could rely on them. As of today, I don't have specific figures, and they're not published like in the UK. From my perspective, the number of cases have not evolved. It's stable, increasing somehow. In terms of technology, I would tend to say that it's exactly the same as in the UK, mostly electronics and life sciences. So no big surprise here, and then I would say a cherry picking of the rest, mechanicals and all this. And then in terms of rating, I've done my review of a few of most cases over the past 2 years, and As you know, in France, we don't have a bifurcated system, not like in Germany. So basically, you try your case both in infringement and invalidity. And French courts are quite keen on maintaining patents, as a matter of fact. It's roughly, I'd say, 60% of validation of the patent in its entirety, and then another 10% of partial invalidity. So French courts, unlike some people have thought back in the days, are quite keen on maintaining patents. Then there's always the option of having a settlement judgment because you don't have the bifurcation system. But they've proved over the past 2 years quite pro-patenty in terms of maintaining patents, I tend to say.
That's interesting. That's also relevant for global enforcement strategies. Obviously, I mean, looking just briefly to Germany and the EPO figures, there you can say it's still roughly a third. 1/3 full invalidation, 1/3 partial invalidation, 1/3 maintenance as granted. In the high-tech area, the invalidation rates are a little higher. They used to be super high some years ago, but currently I would say the low-hanging fruits are gone, maybe similar to the US development, and the rates have gone down a little bit. That has, by the way, as we have a bifurcated system, triggered infringement judges on the patent infringement courts, again in that order still, so to say, Düsseldorf, Mannheim, Munich, maybe at arm's length these days. That has made infringement judges be a bit more careful when it comes to invalidity issues and increase the number of stays, however, not dramatically, I would say. So it's a certain development, but all in all, Germany is still quite attractive for various reasons for patent plaintiffs. Now, case numbers roughly stable. Last year, we've seen a little decline of a couple of percent, especially Düsseldorf lost some percent, so to say, and Mannheim lost a few percent, but Munich gained some percent. And that really leads now to Düsseldorf still being the most important venue in terms of case numbers. Mannheim and Munich being roughly at the same numbers. Munich is this year a little bit ahead, so to say, but still both are far away from Düsseldorf. Düsseldorf is also the only first instance court with 3 panels for patent litigation. Mannheim and Munich only have 2. Absolute numbers somewhere around 1,000 always. I think last year it was in the 800-ish, something like that. And we do count each and every patent as one case.
That's the thing. That's what I was about to say.
just in case you wanted to ask that, Ann-Charlotte. All right. Technologies. Pharma, high-tech, of course. We're seeing a new wave of what used to be the smartphone wars some 10 years ago. That's now the connected car wars. Automotive is everywhere. And it's pools against car makers. It's semi-NPEs against car makers. That's really big news, so to say, since about a year or 2, and that keeps us very busy. The smartphone tablet cases don't go away. They're still existing. Telecommunications infrastructure has increased, and pharma is, as always, I would say. What we're also seeing is an increasing number of medical devices cases, in particular smart medical devices. So that's another trend. Not yet AI, not yet really IoT. That's going to come after the cars, I would guess. So that's the latest maybe in Germany. Maybe completely different topic now, a bit more substantive law. And Lionel, I would ask you to start off because everybody knows eBay Market Exchange. And we're not calling it equity, at least not in Germany. We're calling it proportionality. The question is, how difficult is it to get injunctive relief as a plaintiff in the United States? Maybe comparing competitor litigation with NPE litigation and comparing district court litigation with ITC proceedings.
So for NPE litigation, the answer is very simple. There will be no injunction. It's impossible, virtually impossible to get an injunction if you're an NPE. So that basically takes care of 85% of all cases in the US. which leaves the other 15% for mainly competitor cases, right? So in the competitor cases, can you get an injunction? It is possible, but it's very difficult to do until you've won the case. So what you have to do to get an injunction is you have to file the case, win the case, win the appeal, and then after the appeal, when everything is over, you can then ask for an injunction, and you would have a chance of a good chance at that point of getting an injunction. I wouldn't say it's more than 50% chance, but you at least have a chance. And the reason is most judges find that money can solve all problems. And if you are able to put a royalty rate or an amount on the value that the patent is valuated for purposes of determining how much money was due before you won it before the jury, then if you can value that, you can also value how much money would be due after the jury has awarded. So is it possible to get an injunction in the US? Yes, the answer is still yes, but it takes a lot of time, and it takes, you have to win the case and get to the end. Now, is it possible?
How long does, sorry,
Yes.
how long does it take you?
Three to 4 years. That would take 3 to 4 years.
Okay. Mm-hmm.
Now, is it remotely possible to get an injunction before the entire 3 to 4 year case is over? The answer is yes, but I would say about a 1% chance of getting an injunction in that situation.
So why are there 85% of NPE litigations, in particular tackling the big guys that you just mentioned, which which would have the funds to defend properly, so to say? So what is it? Is it the money? Obviously, what's the strategic thought behind those litigations?
Well, the 85% of NPEs who are filing all the lawsuits simply are filing lawsuits to extract money from the defendants that they're suing. It's in some cases the NPEs are the licensing companies, right? The companies that have no other business but to license their patents. They acquire patents and then they sue in order to achieve licensing. And you know, for every lawsuit that they file, they probably have a factor of 10 or 20 or 30 of licenses that they acquire because of that. So by litigating one case, you let the industry know that you're willing to litigate, and then that incentivizes all of the other parties in that same area to make the payment to you as well. But I should not fail to mention that, you know, you ask about injunction. I was thinking of district court case. Don't forget that we have that specialized court in Washington called the International Trade Commission, where injunctions are the only remedy. There is no monetary remedy in the ITC. The only remedy is an injunction. So if you truly want an injunction, then you can go to the ITC. The exception is the ITC is only for imports. So you can only control what is imported and crosses the borders of the US for the injunction to keep those products out, right? So that is a type of injunction, but it's a very specialized type.
And would NPEs, licensing companies, use the ITC?
Some have. The ITC has a very specialized procedure in that you have to establish that you have a domestic industry. The ITC is basically a way of protecting domestic US companies. And if you can establish that as an NPE, you have a domestic industry, and how that's defined is very complex. But if you can establish that you have a domestic industry, then yes, even an NPE can sue in the ITC to try to keep all products out. I mean, take Apple, for example. Apple makes the majority of its iPhones outside of the US. So if you're an NPE and you sue Apple in the ITC to stop, to enjoin the importation of the Apple iPhone, well, obviously that would be a dramatic effect upon Apple. And so that is a tool that NPEs sometimes use if they can establish that domestic industry requirement.
Thank you very much. That's very insightful. Ian, proportionality or equity in another common law system, how does it play out in patent litigation?
Well, the first thing to say is an obvious point that if we're talking about injunctions, we're talking about final injunctions here, not preliminary, which I think we'll talk about in a moment. So in the UK, the rule with injunctions is that despite the fact that they are an equitable discretionary remedy, in IP cases, if you win, the starting point is that you should be entitled to the injunction. If you want to argue against that, then you have the burden. So of course, the defendant has the burden of showing why the injunction, final injunction, shouldn't be put in place. And that's not easy. In some situations where, just thinking how Lionel described it, money can solve all problems, then maybe you can persuade the judge that a final injunction is not necessary, and maybe certain NPEs may fall into that category. But the interesting thing about NPE litigation in the UK is that it's completely unlike the States. There's hardly any of it. There has been a little bit, but if you look over the last 10, 15 years, while NPE litigation was running rampant in the States, you had a few tentative forays in the UK. Roe v., for example, tried and failed multiple times to create any traction. IPCOM famously got things rather wrong, and equally did not come off very well there. And the reason for that, perhaps, is another topic that we may come on to, which is that the English courts still are probably the place in Europe, and I'll include us in Europe there, if I may, for a little longer. It's probably still a jurisdiction that if you want to knock out patents, that's where you would go. It's certainly not the case that every patent will be knocked out. It's not that patent friendly, and it's much more friendly to patentees these days than it used to be 15 years ago. Nevertheless, it is a formidable court. If you have a patent that is weak, you will be doing very well to defend that patent and succeed. So in those situations where you might be able to persuade the court that a final injunction is not necessary, we've recently, very recently, in the last couple of months, seen an interesting change which comes from the medical device world, and a case to do with devices that go are used in heart surgery. And the parties who were arguing about that were Abbott and Edwards Life Sciences. And what Abbott was saying, in effect, was we already have our product on the market, and some surgeons prefer it. And so even if we're found to infringe, we think our sales should be allowed to continue. Edwards don't obviously like that argument, so argue against it. And ultimately, the judge decided that the patent was valid and infringed, and did order a final injunction, with the very slight caveat that in those situations where the Edwards product had been used, but for some reason the patient didn't get on with it, or there was some other problem, then the Abbott product could be used instead. There's also been a little bit of judicial musing, if you like, about what should be done in the situation where there is no final injunction. How would you compensate the patentee? One view is, well, the old view was that the patentee is entitled to damages or an account of the profits made by the infringer, but it's beginning to be discussed that maybe allowing the patentee access to all of the profits made by the infringer in a public interest situation would be unfair, and that instead the infringer should be allowed to make some profit, and a royalty would be more suitable, as opposed to all of those profits being disgorged away.
Very interesting. So I'm just trying to, I think I heard, you didn't say it, Ian, but that's my understanding. There hasn't been a case yet in the UK where a final injunction was denied because of equity considerations. Maybe just that little fraction in the Edwards Life Sciences case relating to some products.
Yeah, I can't think of a comparison which is perhaps similar to the position that I know exists in the States from time to time. It is much more the situation that if you win, you will be entitled to the injunction unless there's a very good reason for that not to be the case.
Yeah, it's really interesting from a comparative law perspective, because both are common law systems and the results just are on both sides of the spectrum. Let's look to real Europe, Ian, now a little bit. And let's start with one of the most important countries in real Europe, Anne-Charlotte, proportionality in France.
I don't know why I knew I would be the next one. Proportionality, well, first of all, injunctions. There's a difference to be made, obviously, between PIs and final injunctions. And unlike another jurisdiction, injunction in France, final injunctions in France are the rule. I haven't seen a case where actually a court has refused to grant an injunction when it found the patent valid and infringed. Possibly because the NP cases have not come to an end over the last years, so that will be saved those instances. But in the most recent ones, they haven't come to an end. They were either settled before or the patent was invalidated before it went to the end. On the other side, if you look at PIs, as you had noticed, as you mentioned earlier, PIs are back in France, and over the past 2 years, over, let's say, all the PIs that have been launched, a fair amount have been granted. I would say about between a third and 40%. So French judges are more keen on granting PIs. But what you can see in the reasoning when they refuse to grant the PI, you see the proportionality criteria that's coming up. Even though proportionality is not part of the law, it's a criterion that has been set that is being set those days by the courts. And most recently, there's an IPCOM case that they gave it a try. They tried a PI in France. They didn't make it, and the reason why they didn't make it was because the court considered it would not be proportionate, despite the fact that their patent was coming close to expiry. So in terms of trends, I would tend to say that injunctions are still quite automatic when it comes to injunction on the merits. And in terms of PIs, they're becoming more common, but still there would be a little caveat with this proportionality criteria that is becoming, let's say, more, that we see more and more in the presiding judge's decisions.
Thank you. That's very, very interesting. Mattia, you'll be next, and maybe you can talk about injunctive relief, final injunctions, proportionality, but also a little bit about preliminary injunctions in Italy, which I understand you can even file based on a pending patent application. Now, before that, we have now crossed the hour. I would say we just continue a little bit, wrap up, say, in something like 10 to 15 minutes, and allow for some questions then, if there are any. But please, Mattia, go ahead.
Okay, thank you, Tillman. As you know, in Italy, we do not have a bifurcation. So both the validity and the infringement can be evaluated within the same procedure. And this is also the case during interim procedure. I have already said that 60% of the patent cases are interim procedure. And this is the reason thereof is that in the last, I would say, 5-6 years, we have a new evolution of an idea of PI, preliminary injunction, and interim procedure, which bring of having de facto to a mini procedure on the merits. Italy was well known, unfortunately, for the long duration of the court cases. But now, with this evolution of interim procedure, where you have in a time frame of approximately 10-12 months a decision, both on validity and infringement, I think that Italy has becoming really a very interesting platform for litigation. Maybe I go a little more in detail regarding the interim measure. What is if a plaintiff is asking for a preliminary injunction, then usually the judge appoint an expert to conduct a technical analysis on the patent validity and on the infringement, as I said, on which the request for interim measure is based. And during this technical investigation carried out by the court expert, both parties have the possibility to appoint their own technical expert. So that at the end, we have a technical mini trial regarding infringement and validity with exchange of risks among the parties, among the lawyers, and among the patent attorney. So that you have at the end a preliminary decision which is on the contrary quite well-grounded. I would say very well-grounded. This is the reason why a lot of cases end after the decision rendered within the interim procedure, because this technical trial has been dealt by the parties, and so the parties cannot really expect that during the procedure on the merit, the result also on the validity of the patent will be really different. So usually the party after this preliminary decision come to a settlement. Another reason why we have a large number of interim procedure is a part of the preliminary injunction decision is the so-called description, which is very well used, and Italy has a big experience since more than 30, 40 years, whereby the court authorized the plaintiff, assisted by the bailiff and by its technical expert and its lawyer, to access the defendant premises in order to inspect and make a description, taking pictures, making videos of the products or of the processes allegedly infringing the plaintiff's IP rights. And this tool is very useful in order to collect not only this kind of evidence, but also evidence regarding to the identity or the number of clients and of supplier. And then you can also get a copy of all the invoices showing how many products have been sold and so on. And then you can use this evidence for sure in order to request then the damages after that. Last thing, which is probably interesting to know, is that other than in the past, the PI issued by the judges ex parte without having a hearing and with the counterparty are becoming quite rare. So usually if you are asking a preliminary injunction, no matter what are you stating in your request, the judge is not really confident about what is said by the plaintiff, and usually fix a hearing in order to have also the comment of the counterparty. The only the only interim measure where you can more easily get a decision with ex parte are the request of description, because it's clear that you explain the judge that you want to enter the premises of the counterparty in order to verify whether they are infringing the product. And so if you announce that to the counterparty, then for sure, very probably, everything can be moved apart of, in case of big machines, or big equipment, which are not easy to take away.
Yeah, thank you very much, Mattia. Maybe just very briefly on Germany, because that's a hot topic there. Proportionality is being looked at, especially after the famous heat exchanger decision. That means all of us German litigators now write quite a bit about proportionality, why an injunction should not be granted, why there should be a use-by period, and the result is always the same. There is an injunction, which means it's nice, so to say, things to think about and nice things to work on, but we have not yet seen a single case where proportionality worked as a defense. It might work in cases like, Ian, the one you described in the medical device area. We also had the issue in a similar case in the Amgen versus Sanofi litigation. There, in addition, compulsory licensing proceedings came in, but also there, the arguments weren't good enough, so to say, to avoid the injunction. The automotive and telecommunications industries have lobbied quite a bit for a change in the law. Actually, that is on the table. There is a draft already being circulated, German Patent Act revision, and it would cement, so to say, proportionality in the written law. However, the reasoning of that draft law says that it should only, the revisions should only reflect the current state of the case law, which is the heat exchanger decision, which means we will continue to write a lot about it, and we will continue to get injunctions. That's my best guess. The standard to avoid an injunction is very tough. It's called undue hardship. It's probably one of the highest hurdles you can think of in law. Preliminary injunctions, just very quickly, practical tool, happens all the time. What we've seen less and less is ex parte preliminary injunctions. And normally, at least at the important courts, you need to have a tested patent that has already survived nullity or opposition proceedings. That has always applied to Düsseldorf, Mannheim, Karlsruhe. Munich now changed its case law. That also applies to Munich now. And the last court remaining not using that case law, which is, say, relevant in patent litigation, is the Hamburg court. So Hamburg might become more important for PI proceedings now, and we do not know whether they also align their practice with the other three courts. Ian, Lionel, as you won't have much to say about relevance of search and seizure orders or temporary restraining orders, preliminary injunctions, would you mind just jumping on another topic and tell us a bit about, Lionel, use discovery maybe in the context of Europeans being able to use it for European litigation, and Ian, you more about initial disclosure, hide and seek of facts. But Lionel, you first maybe.
Sure, happy to kick that off. So I'm not sure how many people know about this. It's a very special procedure in the US. It's called a 1782 proceeding. And if you have either a litigation in another country outside the US, or you have an anticipated litigation, it doesn't even have to be an ongoing litigation. If your opponent has a location in the United States, you can file a subpoena in the United States to obtain discovery against your opponent in order to obtain information. That information can be basically anything, any type of document or information that you could use for the foreign proceeding. And all you do is you locate where your opponent has an office in the US, which state and which city. Once you locate the state and city, then you identify where you would serve the subpoena. And the subpoena is an order from the court that documents and information have to be provided. You then submit that application to the court. The court will then take about 2 weeks 2 to 3 weeks to approve the application. It's almost always approved. And then you're able to serve a subpoena, a court order on your opponent in the US to require them to provide documents and information to you for use in your foreign proceeding. It's quite useful, it's quite powerful. The courts in the US have consistently approved such applications for discovery, and they have been very, the scope has been quite broad. There's two types of information that you can ask for. One is documentary information. The other is actually a deposition. So if you're familiar with deposition practice in the US, you can also request and obtain a deposition from your opponent in the US for use in a foreign proceeding. And this is very a very unusual procedure, but it's being used more and more. And surprisingly, when I started looking at this about 12 years ago, many opponents would file motions to quash the discovery, saying that it was inappropriate and it shouldn't be issued. And the success rate was a little bit lower 12 years ago. Now the success rate is up in the 90%. So if you have a foreign proceeding or an anticipated foreign proceeding and you file for discovery in the US, you have a very high chance of getting it.
Let me do a little marketing there, Lionel. I mean, I've done it. It works really well, and Lionel is really good at it. But I want to leave it there. Ian, disclosure, hide and seek.
Yeah, very briefly. So I like your description, hide and seek. When you start a patent case in the UK, our pleadings are very light. We don't have to put an awful lot in them. In relation to where hide and seek might be relevant, less so on validity, because those documents are going to be out there somewhere. Much more relevant to infringement. And when we start a case, we do have to point to an infringing product or some infringing act that we're hanging the case on. But we might not know everything about that product, especially if the litigation is to do with process patents, which many drug cases are. We may suspect how the drug is made, but we may not know in fact how it's made. And so there is a little bit of a game that goes on sometimes, which is you plead the case in the best way you can. In America, perhaps you could say something like upon information and belief, which I've always found an attractive way for saying we don't completely know yet. But you may be able to start the case that way. And the risk is, will that attract an application from the defendant to strike out the case on the basis that you really don't know what's going on? The English courts are not very keen on that kind of behavior by the defendant, because they say to the defendant, well, you know what you're doing, so let's not argue about strikeout. Why don't you just tell us what you're doing? And the response is, well, it's all very secret. And the court will say, well, there's no problem there, because as you know, you can describe your process in what's called a product and process description, which is effectively a written document saying how you make the thing that you're making. And then the defendant will say, but all of that's secret. And the court will say, don't worry about that. As you know, we have confidentiality clubs to deal with that. And what that means is, please describe your process, and we will agree that that should remain confidential, and we will restrict the disclosure of that document to those who only really need to know about it. And sometimes that's lawyers only. The clients are sometimes not happy about that, but you can run a patent case and you can talk to expert witnesses via the lawyers without the client needing to know what the process is that you're arguing about. So that's how we deal with that kind of hide and seek situation.
Thank you very much, Ian. And that's a perfect teaser, because we have so many topics left on the list which we can't deal with today. I would propose that we maybe do another time, another session, in particular covering then confidentiality club issues, confidentiality protection in patent litigation, trade secret stuff. all these kinds of things. But I do think that we exhausted the audience by now. I need to tell you, audience, that you please participate in the evaluation, because only if you do so, and only if the evaluation is good, only then we're going to do another round, including the confidentiality club session. I remain with thanking my speakers, my panelists. It was really interesting. I learned a lot, and I wish everybody a good day. Dana, you take over now for how the evaluation works.
Sounds great, Tillman, and thank you for moderating interesting conversation. Thanks to all the speakers for speaking. Going back to your first one on kind of the effects of COVID. Lionel, I don't know if you mentioned IPRs. I don't know how much of your practice is in front of PTO, but over the last 5 years or so, they've been spending so much time doing video conferencing, or some judges there, some not. So I wonder actually how that transition is.
It's actually quite awful.
Okay.
Because now that we've transitioned, the PTAB is doing all of their hearings by video now, not in person. And with the screen that we have right now, we can see everyone's picture, and that's sort of okay. But when you have the judges, it's not as clear as what we have on this Zoom. So when you're making your argument, like if I'm looking at you, I can tell right now that you have a smile on your face and that you're probably not annoyed with me. But you can't always tell that with the judges, right? And when you're in person with a judge, you can look at the judge, and if you can see that your argument is winning, then you know to limit your argument or to not go on. If you can see that the judge doesn't believe a thing that you're saying, then you can modify your argument. If you don't have that level of clarity, because if there's a presentation on the screen and the judge's image is not readily accessible, then it makes it much more difficult.
Yeah, PTAB judges are terrible at hiding their emotions anyway. So, but with Lionel's help, that was my filibuster, Tillman, to allow people to fill out the poll, which is now up on the screen.
You Americans just talk to yourself, and that's fine.
We can do that. That's fine. That's fine. But all right, again, I want to thank you. Happy to host a follow up. As I said, I thought this was a great conversation. We're also trying to figure out what other types of content we can do at LESI during the COVID that's timely. I thought you incorporated a bunch of elements here and kind of short that people can get in and out. So look for that more. As I keep saying, LESI has gone virtual. You all have helped us do that. So thank you for that. And with that, I think we can close the session and give people maybe a few minutes back on their schedule. So thank you all very much. Have a good day.
Thanks.
Bye-bye.
Bye.
Thank you. Thank you, Tina.
Thank you. Bye.
Bye.
Thank you all.
Okay, the only one still there. Okay. Then, ciao Dana. Oh, no. Okay, Lionel is coming back. I want to say many thanks to Tillman, but I don't know whether it's still there or not.
Yeah, I'm not sure. We still got a few folks that are still in the room here. I don't know if we wanted to do a debrief, but let's see.
Mm-hmm.
I logged out and logged back in.
Okay, the last one. No, so we are.
I'm going to stop the recording.